of this emerging field and how it addresses climate crisis. I think I want to say, following on Jack's comments, that environmental law has only one job. It's to respond to nature's laws. And if it fails to do that job, we can have the biggest EISs, we can have the most citizen suit victories, but in the end, if we fail to respond and adhere to nature's laws, we will have failed and society will pay the consequences. And so this is another way of saying just what Jack did. The approach we take to climate must actually address climate imperatives. It must address carbon math. And no micro approach that I know of does that. No Clean Air Act approach, no Endangered Species Act listing approach. Now, these micro approaches are very important to plug the holes in a failing dam. I'm not saying they're not important. But we need a macro approach geared to what the climate imperative is. I often do something at conferences like this. I ask environmental attorneys, do you know what the climate needs to reach equilibrium? Every single atmospheric trust litigation attorney in this country, and there's a growing cadre of them, can tell you what the climate needs. Most other environmental attorneys I have asked have no idea. No idea how much carbon reduction is necessary to achieve climate equilibrium before this planet passes the tipping points into runaway heating. So I will talk about the climate imperative because that forms the fiduciary obligation for this trust campaign. But before I do that, I just want to note in a big picture way that if the law is not relevant to this crisis, and it has not been so far, we've had 30 years of climate-like laws and certainly a number of treaty negotiations. We've had litigation in the Clean Air Act and so forth. If it's not been relevant so far, if it's not relevant, then the law simply is not relevant. Because climate crisis is the big whammy. It is the unimaginable consequence. It is not sort of recreating on a beach anymore. This is human survivability by the end of the century. The former dean of Yale Law School, Gus Speth, put it this way in his book, The Bridge at the Edge of the World. He said, if we don't drastically change our ways, the world by mid-century, 40 years from now, in his exact words, won't be fit to live in. So you take that quote, and every time I hope you see a young child who's going to be around the age of 30, 40, 50, whatever, by mid-century, just think of that quote. Because the law has not done anything to make the world fit to live in by mid-century. So atmospheric trust litigation was conceived in that framework, thinking of nature's own requirements. What we need is a planetary approach, a legal obligation that can be enforceable by citizens literally all around the world, in every state in this country and in every country in the world, except for the totalitarian governments. You really can't do much about them. But we need an obligation that actually galvanizes people as well. Our environmental laws have tended to marginalize many of the common people. You try explaining, a Clean Air Act standard to a common person, they just, it's impossible. It's so complicated. It does not inspire. So we need not only a legal theory that positions courts to force carbon reduction, but we also need a legal theory to form the crux of a political movement that gets to the heart of the matter, that gets to the right of children alive today, future generations, to survive in some degree of comfort by the end of the century, their right to atmospheric property. So the trust is what many of us believe that approach. It's not surprising that approach because it has been around since really the dawn of human civilization. It's a very simple concept that the people give power to their governments, whether you're talking about states or different countries or this country. And in giving power to their sovereigns, they only give so much power. There's a limitation on that power that the sovereign cannot allow destruction of resources that are crucial for the citizens' welfare and survival. In other words, we don't give the power to the federal government to allow fossil fuel corporations to destroy the atmosphere so that our own children will suffer miserably by the mid-century. We have not given that power. This trust obligation is now seen by many, many scholars, not as some statehood doctrine, you know, Jack did a great job addressing that. It's a fundamental attribute of sovereignty. It is constitutional in nature, and John will describe that more. And so when you have the trust invoked, you view these natural resources as common property. So the air and the atmosphere is held in trust by the government for us, but we're the actual owners. We are the beneficiaries of this common property. The beneficiaries are present and future generations. This isn't some new doctrine that someone just made up. This is in hundreds of court cases. Same. The states and a couple cases at the cutting edge, the federal government is trustee of property for the people. Now, what that means is, as trustee, the government has a duty to protect that common property against, and this is the legal term that emerges from the cases, against substantial impairment. In other words, the government must protect the functioning of that asset. So when you get to climate crisis, you can see we are at the edge of this atmosphere not being able to function. And I cannot stress this enough. Once we go beyond that tipping point, wherever it may lie, we go directly into runaway heating. And you can just knock every possibility out of the ball field there. There's nothing we will be able to do, even if we cut all carbon the next day. So we are talking about the functioning of our atmosphere. Atmospheric trust litigation is an unprecedented legal campaign. It takes this public trust and it applies it to climate in a way that can empower youth and attorneys all across this country and indeed all across the world. It says the atmosphere is held in trust and the fiduciary obligation to protect it is the obligation to return carbon dioxide concentrations in the atmosphere to 350 parts per million. How many people know that number, 350 parts per million? Okay, so most of you do. This is the number that climate scientists have settled on to achieve, to indicate climate equilibrium. In other words, if we bring climate or carbon concentrations back down to 350 parts per million, we have a chance of restoring climate equilibrium. Right now, they're close to 390 and climbing. They climbed carbon concentrations climbed, but also our emissions climbed 6% last year. So we are still on the trajectory of loading up our atmosphere with this deadly pollution. And we have to bring that trajectory back down through litigation. So atmospheric trust litigation, which I'm going to call ATL after this, says the property has to be protected in a way that the globe brings down carbon emission in time to achieve 350 by the end of the century. Now, that's a very positive thing. I mean, to even think we can achieve 350 by the end of the century, and we can tell our children we're working towards that, that we don't even deserve that hope at this point, but it's wonderful to still have it. We will not have it in a few years. In other words, this window is slamming shut. And that is why I can't stress enough the urgency of this crisis and how the law must gear to that. So the fiduciary obligation under the trust is to achieve that trajectory of carbon reduction that will bring atmospheric concentrations to 350 by the end of the century. Now, I'll bet very few people can tell me what trajectory that is. In other words, if I ask you, how much carbon emissions will it take to get down to 350 by the end of the century? That is the key question. 350 doesn't really mean anything unless we know how much carbon reduction to bring down. It's like a cholesterol test. Oftentimes I use this as an analogy. If you go to the doctor and the doctor says, your cholesterol is off the charts, you're going to die unless you bring it down, have a nice day. You know, a doctor wouldn't do that. A doctor would say, you have to bring it down to this level, and a doctor would set some sort of plan with a check-in point. That is what atmospheric trust litigation does. Jim Hansen, Dr. Jim Hansen, the head of NASA's Goddard Institute for Space Studies, developed for this litigation a trajectory with the world's most renowned scientists. And the trajectory is the heart of this litigation because this litigation asks courts to force governments to do this. And the trajectory is bringing carbon emissions down on a global level 6% a year. So remember, that's the key figure, 6%. And to level emissions growth this year. So whereas last year our emissions went up 6%, we've got to this year level that, and then next year start bringing it down 6% a year until we reach zero emissions. Now it's a very simple construct, but if we even wait a few years, that 6% jumps to 15% a year, then 20% a year, then 50% a year. It becomes undoable. So we have this incredible opportunity now to do it. Atmospheric trust litigation amounted to a hatch of cases in May of last year. And this has never been done in the history of law. There was a hatch of 50 lawsuits and petitions. There were about 9 lawsuits, and the rest were state administrative petitions that are moving into the lawsuit stage now. And this was a hatch that all happened on one day, back in May, asserting the same obligation against every single state in this country, using the same fiduciary standard I just told you about. They were all filed on behalf of youth plaintiffs. And this has never been done in the history of law. Tobacco litigation is often cited, but that was sort of a dribble-out approach. We don't have time for any sort of dribble-out approach anymore. This is the only macro approach to climate crisis. It is asking for a particular remedy. The remedy is for a court to order the trustees. There's a federal case, so in the federal case it would be the federal agencies. But all the other state cases are state cases, so it would be to order the states and the federal government to develop a climate recovery plan